Do you know that the probate is no longer required for transferring your flat? Even in cities like Mumbai, Chennai, and Kolkata. From 1st January 2026, one major rule has changed. If a flat owner dies without making a will, probate is not compulsory for transferring that flat. Many families, buyers, brokers, and even housing societies still believe that without the probate, the flat transfer is not possible. But after the recent amendment, the legal position has changed. Till now, the common understanding was that if there is a will, first go to the court, obtain a probate, spend time and money on all the legal proceedings, and then only the flat can be transferred. This understanding mainly came from Section 213 of the Indian Succession Act 1925, in which the probate was treated as a compulsory document to transfer your flat, where the will is there in place for the succession of Hindu, Buddhist, Sikhs, Jains, and Parsis. But after the repealing and amending Act of 2025, Section 213 has been omitted, which means that from January 2026, probate is no longer a compulsory document for claiming your rights under the will. But be careful, this does not mean that probate is abolished or probate is useless. This does not mean that society must blindly accept any document called a will. And this does not mean the legal heirs lose their right to raise objections if the will is doubtful. The correct position is this: if the deceased flat owner has left a valid will, the housing society should not mechanically say, first bring the probate, otherwise we will not even consider the transfer. Instead, the society has to examine proper succession documents. The society can still ask for a death certificate, copy of the will, application from the claimant, affidavit from one or more of the attesting witnesses, indemnity bonds, NOC from other legal heirs wherever required, and any other supporting documents based on facts of the case. Now, one more important point: under the Maharashtra Cooperative Societies framework, the society may have to deal first with the nominee. And as per the amendment in the Societies Act in 2025, the person may first be admitted as a provisional member till the final legal heir or successor is properly identified and admitted as a regular member. So, after January 2026, can society insist on a probate in every will-based transfer case? The answer is generally no. Probate cannot be treated as a compulsory precondition in every case merely because there is a will. But this is where the families must also be practical. Even though probate is not mandatory in nature, it can still be very useful. For example, if the flat is of high value, if there is a family dispute, if there is a chance of one heir likely to challenge the will, if the will is very old or unclear, or if a buyer or the bank wants a stronger title comfort, then probate may still be advisable, because probate gives a stronger court recognition to the will. It reduces the future disputes and gives comfort to the purchasers, banks, and institutions dealing with the property. This is the big change every flat owner, legal heir, buyer, broker, and society committee member must understand.